Hi, my name is Rachel Marks, and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Rick Sissman, a construction lien law guru. The topic on today's webinar is Subrogation and Notice to Cure in Maryland construction contracts. Now, let's get started.
Good morning, Rachel. Rick Sissman on behalf of Fracassi Sussman Rand, LLP. We practice law in Maryland, DC, and Virginia, construction law. And today we're going to talk about subrogation and notice to cure in Maryland construction contracts. If you'd like to go to the first slide. What I'm going to discuss today is that you as a contractor, if you were hired by a homeowner to perform a scope of work at their home, first of all, there are several things you must have, one of which is that you must be a Maryland home improvement contractor licensed with the DLLR. Failure to do so can put you in jeopardy of collecting any and all of your monies once you have completed your contract, or even during the course of the scope of your contract. As you may know, under Maryland home improvement law, you as a contractor can only take 1/3 up front, and the remaining portions of your contract can be received contractually as however you please with the homeowner. Now, what happens if there is a problem whereby for some reason one of your workers has screwed up? And by way of example and not limitation is that you're putting in a new sewer line and you forgot to cap the sewer line, and all of a sudden there's a rainstorm, and all of a sudden there's flooding into the home of your customer. Well, normally what you should do is immediately contact your liability policy insurance carrier. They most probably will cover you for any damages that were created due to the floodwater, and that's damages due to the home. And most probably, if there's some personal injury damages, that should also be covered. The homeowner's carrier, in turn, will contact your carrier. And the first thing is to contact, once you've contacted the carriers, once the carriers have made contact with each other, then the work will begin. Normally, the homeowner's policy will cover the damages due to the water penetration of the house, which could be drywall and drying the house, cement damage, carpet damage, etc. The homeowner, the doctrine that we are talking about is called subrogation. Now, what is subrogation? Subrogation means that the homeowner's insurance company is called the subrogee, and the subrogor is the homeowner. Normally, the subrogor will in turn assign all of the homeowner's rights to the insurance company, and the homeowners will then usually sign a release, and once they have had all the damages corrected. So once that has occurred, then all the rights and obligations transfer to that of the insurance company for the homeowner. The insurance company for the homeowner, known as subrogee, will then contact your insurance company, and depending on the situation, your insurance company, less your deductible, of course, will then in turn pay the damages back to the insurance company for the homeowner. So if the homeowner then is in a position, and I've seen situations where homeowners for some reason may end up suing you for damages that are not covered by the insurance company. And then you're in a litigation mode, and normally your insurance company most probably will not represent you, and you'll have to hire independent counsel. But you should always check with your insurance company to see if in fact they'll step in and give you further representation. Now, the release that I discussed a few moments ago, I would highly recommend that you discuss this with your insurance company, because if the homeowner fails to sign the release, that could be problematic for you, because they may say, well, we never released our rights to pursue the contractor for damages that were not incurred. However, you as the installer of the sewer pipe, and have you completed that work, which normally you would have, you are still entitled to receive compensation for the installation of the sewer pipe, because the homeowner is not entitled to get a free sewer pipe. So your damages would be limited to that of the installation of the sewer pipe. So a homeowner does, and the language that you see on the screen is the language of a release that I would recommend, and normally the insurance company will allow you to put that language in, or they'll put that language into their release. Now, what can you do to prevent other damages to be assessed? Well, in the body of your contract with the homeowner, you can have them waive consequential damages and incidental damages. The Maryland Consumer Protection Act will allow such release as long as the type of damages that you are releasing are not considered what's called unconscionable. So what would be an unconscionable type of provision in your contract? An unconscionable provision would be something where you're saying, in the event a homeowner is injured, physically injured due to the acts or omissions of you, that is an unconscionable provision. But for most parts, incidental and consequential damages you can put in your contract, and for the most part are enforceable. And a consequential damage is a damage that's not directly related to that of the underlying incident. So it could be where taking off time from work, the homeowner had to stay home. That would be a consequential damage, and most probably not covered under any policy, or you would not be obligated to reimburse the homeowner for lost income by going to work. Something similar of that nature should be covered if you have such language within the body of your contract. Because a person is entitled to subrogation, they stand in the shoes of the creditor, and he is ordinarily entitled to all the remedies of the homeowner. So as stated before, the homeowner's carrier will come after your insurance company, and actually you, if you don't have any insurance to cover those type of damages. Let's move on to what's called a notice to cure. A fundamental concept in construction law in Maryland is the right of a contractor to be provided a notice to cure and the right to cure any alleged deficiencies. My recommendation is that in the body of your contract with the homeowner, you should have a provision that says, in the event there is a part of the subcontractor's work, your work, that is not done properly, or they're claiming a back charge, you have a right to have a notice to cure within X amount of days, which you can put in the body of your contract. And in the event that the homeowner does not contact you within a timely basis, and say they end up hiring someone else to come in and perform the work, then they have waived the right to pursue you in the event they are charged for a fee by the replacement contractor. Now, in the event you are given a notice to cure, however, you decide you do not want to do the work, it is conceivable that the homeowner, in the event there's a nexus between the damages caused and your work, they could come after you. But that's why I always recommend in the body of your contract, you have notice to cure. So you have the right, the first right, to take care of any alleged damages. And you could either contest it or you can say, yes, I will repair that damage. So you don't have to be back charged, or they'll come after you for damages that they paid to a replacement contractor. And there is specific case law in the state of Maryland, and this also goes for warranty too, that as to issues of cure. If anyone has any questions, please let me know. Otherwise, this will conclude our seminar today.
Wow, what an incredible webinar. I cannot thank you enough, Rick, for educating us on this very, very important topic of subrogation and notice to cure for the state of Maryland. Let's see, right now, I don't see any questions that have come through. However, if you guys think of anything, after the webinar and you're like, oh, I should have asked that, feel free to reach out to us and we will gladly answer any questions that you may have. Now let's see, our next webinar is scheduled with Rick for Friday, May 19th from 9 a.m. to 9:20. And this topic will be getting paid faster with liens, bonds, and contracts. So I hope everyone has a sunny day and we hope to see you on our next webinar. Thank you so much.
Take care. Thank you.